Steve Wilkes of the Wagner Law Group. Welcome to our webinar today on some of the couple of trending topics under the Investment Advisors Act. We're glad to have you with us today. I thought that specifically today, some items of interest that are of current interest and that we're getting questions about from our clients involve proxy voting, some social media questions, and some things about valuation. I chose these topics, for a couple of different reasons. Number one, many of our clients are investment advisors or, dual registered broker-dealer investment advisors, and in addition to our ERISA and retirement plan focus, need to stay very much aware of what's happening on the securities law, SEC, FINRA side of the fence. We get a lot of questions. And, there's some recent changes in terms of proxy voting that I'll just update you on from the securities law side. And there's some recent developments on social media as well. And I thought about the valuation issue and wanted to put it out there because even though many of our advisors and broker-dealer clients are dealing with, publicly traded, ETFs, mutual funds, registered, not necessarily hard to value securities, we're seeing more and more attention on some alternative investment classes, fund-to-fund hedge funds, or maybe some alternative things in real estate or what have you. Now, whether or not that belongs in a retirement plan portfolio, we can talk about some other time, but it raises some interesting valuation issues because they're not necessarily as easy to value. And as I've said before in some prior webcasts, when we do work with you on these issues, we oftentimes will coordinate with your consulting firm, who sometimes has the ability to be a little more efficient than we are in terms of legal rates, but sometimes the issues are more complicated and sophisticated. We'll take them square on. So, we can coordinate with you the best way to work with you on that. Okay, so proxy voting. We're seeing more and more of our advisory clients taking on the responsibility for proxy voting. I think, the default position has tended to be, that's one thing we don't do. We'll work on your lineup and your investments. We don't handle proxy voting, but we're seeing more and more people taking on, which is why I wanted to mention it. Maybe it's a way to differentiate in the marketplace, or clients just expect you to do it when you're exercising discretion on other matters, so that should include proxy voting as well. Typically you'll see that question handled in the advisory contract itself. It'll say whether or not the advisor is going to exercise voting rights, on behalf of the client with respect to the securities, and it's really a business decision, if you will, or a risk allocation decision that advisor can allocate, with the parties. Sometimes they might get a higher fee for it. Sometimes they might not. I mean, clearly, as a fiduciary, an advisor would have to always vote proxies in the best interest of the client. I think the challenge has been that there's really not been a lot of guidance. We have some information from the Department of Labor, kind of on the retirement plan side, the fiduciary side, from the old days of managing pension plan assets. And there really hasn't been that much traditionally over the years from the SEC in terms of guidance, though there were some regulations put out in 2003, a couple of no action letters in 2004 or 2005. And the Advisors Act itself doesn't really, say all that much about it. Clearly, we have it, going back to 03, do have the rule, 206-4-6, which governs proxy voting, and under that rule, advisors are required to, have written procedures, describe their proxy voting policies and procedures to clients, and give them copies on request, and to disclose information, to the clients about how they can obtain information about how they actually voted. And it's interesting because the Advisors Act doesn't necessarily, this rule applies to advisors who are, registered with the SEC and who exercise, proxy voting. It doesn't necessarily apply to others, but there's a little bit of a gap there. I think practically speaking, an advisor's contract needs to be clear with who's responsible for this and have the right provisions in it. So that's something that we see coming up. that's important. The compliance, there's a requirement for compliance policies and procedures. There has to be a written policy and procedure in place that you've adopted. I'm not sure the last time everyone checked those. They can be interpreted pretty broadly. It's pretty clear that you don't have to have, you have different sets of procedures if you wanted. And, the old rules were pretty clear that, an advisor I say the old rules, the current rules, pretty clear that, an advisor need not vote every proxy. There might be occasions when not voting a proxy, could actually be in a client's best interest. But again, these things need to be spelled out. In terms of, sometimes there's a conflict of interest scenario regarding proxies that need to be addressed, and I think the way to handle that and what the regulations require is that if there's a conflict, it has to be disclosed to clients. You should get their consent before you vote. If you do vote, maybe it's just in accordance with a predetermined policy, or maybe you vote according to the recommendation of an independent third party in that instance, or even just outsource it in certain situations to another party. There's also some disclosure requirements about voting information. As I said before, you have to describe your policies and procedures. There's some record-keeping requirements. You have to provide clients with a description of your policies, and upon request, you have to give them a copy. And, this has to be just a summary, not a complete, just a meaningful summary, not a full blow-by-blow requirement. And so there's a lot there behind exercising the decision on proxy voting. This is just by way of background, by the way. If you're advising a mutual fund, if you're advising a 40 Act company, that's a totally separate set of rules. We're not going to go into those today because I think those are a little bit perhaps beyond what this conversation is about. But then again, so that's what we have basically under the SEC rules. We know the DOL back in '94 issued their interpretive bulletin 94-2, pretty comprehensive. And that clarifies whether the advisor or the named fiduciary, typically the employer, has the responsibility to vote proxies. It encourages, doesn't require, but it encourages the establishment of written guidelines concerning proxy voting, which in our book means you should have a written policy. Gives you a little bit of guidance as to whether proxies must be voted in all instances. So again, there's a lot here in terms of allocating fiduciary responsibility, and if you do allocate the responsibility, what is retained by the employer, even though the advisor picks it up, that's kind of an art in and of itself. I also referenced on here there was an interesting letter back in 1988, a DOL information letter to Avon Products, where they spoke on the question of proxy voting. So that's by way of background. Where are we? Why are we talking about it today? We're talking about it today because there's been a little bit of an update. A couple of months ago, the SEC came out with an update. It was in the form of a staff legal bulletin. It was on June 30th, and they covered various issues in proxy voting. The investment management staff weighed in on this update, and they provided some guidance about the responsibilities of investment advisors when they vote client proxies. And also kind of the responsibility if you retain a proxy advisory firm, which I think at the institutional level, some advisors are more akin to doing. The corporate finance staff also weighed in this staff bulletin with some things aren't necessarily of applicability for today's webinar, but it's some of the exemptions about the proxy rules. So this was an update to the regulations from 2003 that I mentioned earlier. I think it provides some clarity. No real game changers per se. It provides some clarity, and it's useful to be aware of where this is going. I think that it was in a question and answer format, by the way. It's really, really helpful to read that. If anyone wants a copy of it, shoot me an email or respond at the end of the webinar today, and we'll get you one. The SEC staff, they give some examples of things that advisors might want to do to demonstrate that proxy votes are being cast in accordance with their clients' best interests and in a manner that's consistent with the advisor's, internal proxy voting policies and procedures. And they acknowledge that although there are different kinds of proxy arrangements that may be agreed upon between the advisor and the client, nonetheless, a registered investment advisor always must exercise its proxy authority in compliance with, the SEC's proxy rule, 2064-6. And, they talk about some of the factors that they believe are relevant that, an advisor should consider when determining whether to retain an advisory firm or not. That's a little bit beyond the pale for today, so we're not going to go that deep into that part of it. But specifically, coming back to, question number one, they basically said, what steps could an advisor do to demonstrate compliance with all the things it's supposed to do on proxies? And I think what they're really saying is that in light of the fiduciary duties that an advisor owes its client and the particular specific requirements under the Proxy Voting Rule from under the Advisors Act, the SEC staff says that some of the following steps might demonstrate that proxy votes are in fact being cast in accordance with their client's best interests and the advisor's internal procedures. And they talk about things like periodically doing a sample of your proxy vote to determine whether they're in compliance, an annual review of policies and procedures, things like that. So that's really, really helpful, I think, for you to be aware of and to think about in terms of, what you have. Again, they go on to say that you don't necessarily have to vote every proxy. You can allocate this authority among yourselves, and that this should all be spelled out pretty clearly in the investment advisory agreement. They do, again, as I said before, they always emphasize that whenever you're exercising voting authority, it must be done in a way that's consistent with the proxy voting rule. So, I think at the end of the day, when all is said and done, they have a few things there. Question 3, they're talking about the advisory firm. How do you choose an advisory firm? I'll just say you look at, make common sense, the quality of the staff, the depth of their policies, and so on and so forth. So I think at the end of the day, what they're saying is that we have a little bit of an overview on what an investment advisor's obligations are when voting proxies, when retaining an advisory firm, the factors that an advisor might want to consider when discharging its responsibility. And most interestingly, they kind of finish this at the end of this interpretive bulletin. The staff is saying that they expect that investment advisors who don't already have these provisions baked into their policies and procedures, i.e. the factors that are discussed in this latest release, they say that they expect them, quote, promptly, but in any event in advance of next year's proxy season, which is coming up right around the corner. So I think the bottom line takeaway here is that it's probably a good time to check your internal proxy voting procedures. How do you discuss it with your clients in your advisory agreement? What are your internal policies and procedures on proxy voting? And give it a look for kind of industry best practices and staying in line with the SEC update on proxy voting. And for those of you that are in the retirement plan business as well, and making sure that aligns with the Department of Labor requirements. That's it on proxy voting. I hope that was helpful. Now, social media. I did a webinar a couple of months back on social media, and if you refer back, for those of you that attended, the handout I think goes over some things pretty well. Or if you just shoot me an email, we'll send you a copy of the PowerPoint slides on that from that social media overview. We've had some recent guidance, which I wanted to bring as the focal point of today's conversation. But first, I think I can just tell you, really, really quickly, by way of background, social media, we're talking about, the electronic, we're talking about the internet. We're talking about, Facebook and emails and posting on websites and online communities and all those kind of things that are going on. And, this can be interactive, it can be static or third party. There's lots of different types of content out there. I think Facebook and LinkedIn I'm seeing very heavily used more and more in the financial service community as a way to network among professionals and provide information. A little bit on YouTube, and of course Twitter is taking off at this point. Typically, with the kind of things we see are, it's in some way, shape, or form, promoting an advisory service, some form of quote-unquote advertising, maybe indirect references to testimonials, or maybe even what your track record is like. It's an area that's heavily regulated, of course, because you're a fiduciary. There's a lot of compliance involved here under the Advisors Act in terms of the procedures for how you would do this, and record keeping and supervising people that are out there. The SEC and FINRA are definitely, on board looking at this. As I mentioned before, they back in 2011, the SEC went out there and really did an exam on what was happening. In 2012, they posted a risk alert on social media, and it related really to third-party content and advertising. FINRA has done its own, issued its own guidance on social media and remains very, very focused on it. So at the end of the day, I'm simply saying this is an evolving area that we're aware of, needs to keep track of, and what's the latest? What's happened recently? So we had some guidance from the SEC, in addition to all the prior guidance they put out in March of 2014. And it came from the Division of Investment Management. And, really, this was a little more focused. It was about the use of public commentaries on social media and websites. And I think, they understand the increased use of social media and the Internet, for people to research and conduct due diligence on service providers. So they want advisors to apply, the standards under the Advisors Act, what we refer to as the Testimonial Rule. I'm sure most of you know what that is, when they're using social media to bring in testimonials from independent third parties. And that's what a lot of this was about, specifically Testimonial Rule, bringing in third-party commentary, put out in a really nice Q&A format. Testimonials are basically anything that talks about a client experience that they've had with you. That's not too hard to define. Of course, the Advisors Act prohibits generally, engaging, in any act, practice, or course of business which is fraudulent. They want the SEC to put out rules that are designed to prevent the same. And the Testimonial Rule says that it's considered, fraudulent or deceptive to directly or indirectly publish or circulate or distribute any kind of testimonial concerning the advisor, or any advice or analysis or report or other service rendered by the advisor. And although the rule itself doesn't define testimonial, we know that generally that's meant to mean, any statement of the client's experience with the advisor. So an advisor's publication, of commentary that's a statement of some client's experience with, or an endorsement of the advisor on the website or a blog or some other social media site, it would violate the testimonial rule. And historically, the SEC hasn't allowed it. It's been prohibited. You can go back and refer to some no action letters. On the other hand, when an advisor, I think what the SEC is saying is that when an advisor publishes an article by an independent, unbiased third party regarding that advisor's performance, that in and of itself is not a testimonial if it doesn't include a statement of a client's experience with the advisor. So it's kind of a tough area. So we have some new guidance now, this Q&A format, and what they're saying is that when an investment advisor or its financial representative, they can publish an advertisement that features public commentary about them without violating the testimonial rule. And this always depends on the facts and circumstances, but there are sort of three conditions or three criteria that they would look at to determine whether or not the testimonial rule was violated. They're looking first at independence, and what they're saying is that this independent social media site provides content that is independent of the IAR. I think that makes sense. Then there's kind of a materiality condition, no material connection. What it's saying is that there should be no material, must be no material connection between that social media site and the advisor or its IAR that would in any way call into question the independence of the independent site. And finally, full disclosure. They're saying that the advisor must publish all the unedited comments appearing on the independent social media site regarding that advisory firm or independent advisor rep. And you can't delete or hide negative comments. The publication, it has to kind of be content neutral. Either present it, like sometimes we'll do it in chronological order, sometimes alphabetical order. try to show the pluses and the minuses, with equal visibility, so that no way it's the ordering or sequence is suggestive or trying to influence a certain outcome in the reader. Going back to that materiality connection also just for a moment, I think this condition is not satisfied if the advisor directly or indirectly authors or submits commentary that appears on the independent site. But an advisor or its independent or its financial advisors could advertise, if you will, on this independent site, provided that it's apparent to a reader that this material is separate from the public commentary that's featured on the independent site, and the receipt or non-receipt of advertising revenue do not in any way influence the public commentary that's included or excluded. So again, there's a lot of ways to jump in and out of this. But those are three kind of updates in terms of social media that are really important, that should be factored in as people rely on social media. This guidance, by the way, this update, I should say, also it added a couple of other things. It said that a list of quote-unquote friends or contacts on your social media site that's viewable by the general public does not in and of itself implicate or violate the testimonial rule. And that if a third party creates or operates one of these community chat rooms or fan pages, and that generally won't implicate the testimonial rule, although the SEC is very cautious about it. They really caution advisors when publishing content from these sites or including hyperlinks or directing people to them, especially if the sites don't otherwise meet the material connection and independence connections that we've already discussed. Interesting. One final thing, they abandoned in this update, the SEC kind of abandoned a prior position that it had taken on investment-related commentary, on non-investment-related commentary about an investment advisor rep, such as religious affiliation or community service. So I think they loosened up their position on that. Just a little bit, kind of interesting. So I'll send you a copy of this, or if you have any questions on it, please make sure you let me know. The final thing I wanted to talk about today is valuation, and the reason I mention that is because a couple of things. Number one, for those of you that are working with putting together portfolios, and valuations are easily obtained by opening the Wall Street Journal or looking at Morningstar or some other service, and we're talking about mutual funds and ETFs, individual securities. Valuation is never that, well, it can always be hard, but it sure is easy. It's a lot harder when you have illiquid assets or alternative asset classes, harder to value assets. And the reason I'm mentioning this because we're seeing more and more of our advisory clients are putting together their own portfolios that might include maybe a non-traditional asset class or some non-traditional investments, or they inherited a plan that has something in it, or they're looking to maybe get a little bit of non-market correlation in a larger plan. They're looking at fund-to-fund hedge funds where they have to really understand, maybe they're either creating a portfolio where they have to report on the valuation of non-traditional assets, or they're simply looking at someone else's report of a non-traditional asset, and they really have to understand what that valuation is all about. So it's getting to be a little bit of it's an area that we're seeing more of from our advisory clients. I wanted to bring it up today. Clearly, the SEC, they've been looking at this for a while. It's been at the top of their exam priorities, and given that the traditional relationship between fees and the value of assets is what it is, it's one that they look at pretty carefully. Typically, at least in terms of reported issues, you see this more for valuation. I guess you see it more with 40 Act companies, where fund boards have to value securities. But the SEC expects all advisors, not just advisors to 40 Act companies, to really be aware of asset valuation. And as I said, we're getting a little more here, so I want you to be thinking about it. The consequences of improper valuations, it might drive fees. Values are assessed on I guess, on value. It drives performance and fees and revenues and what have you. You see it a lot in the private equity space and hedge fund space. So it's something that we really need to be aware of. And we have, not all securities are easily tradable or liquid. Some markets are not as active. They don't necessarily trade or get valued every day. So it's something that people need to pay attention to. Now, the Advisors Act, as we all know, generally prohibits, an advisor from engaging in any practice, or course of business that operates as a fraud. And clearly, the Advisors Act is interpreted as one that doesn't suggest, but it does impose a fiduciary standard. So there's a lot of responsibility here from that perspective, from the SEC side, in terms of anti-fraud provisions and fiduciary standards. And you've also got the the financial side, the FASB. They have FAS 157 is out there on valuation, and back in 2005 or 6 or maybe it was 7, there was a rule change in the way that fund managers and others have to value and report illiquid investments other than original cost. So this is an area that's definitely emerging. So what do? You're either putting together your own portfolio for which you have to report, or you're assessing a potential investment in something that has hard to value assets. I think traditionally, the valuation experts and the industry standards have kind of broken it down in 3 ways. They kind of, we have level 1 assets that are, that's kind of the market approach. That's not so hard. Basically you give the highest priority or the highest level of reliability to quoted prices in an active market, and that's pretty reliable. We also have level 2 assets that it's kind of referred to as the income approach. If you don't have a ready market, FAS 157 would say that you then look at you calculate based on, I think they refer to it as observable market criteria or market inputs. And basically it's a valuation technique. You're taking future amounts of money and discounting it back to a single, to a current, net value, to a present value. And again, there's a lot of art and a lot of science to this, but that's the way those assets would be handled. Then level 3. Kind of what they call the fair market value or fair value approach. This is like the lowest reliability, if you will, but you don't even really have the cash flows to look at, and you just have to use management estimates and certain assumptions, that people use in pricing the asset. And cost approach, or replacement cost might be used. There's a lot of different ways to go. But anyway, the point is that there's a lot of attention being paid to valuing these assets, and it's difficult and something that you need to be aware of in your practices. Clearly, the SEC is engaged in monitoring what's happening there. We've had some very interesting actions. I know there've been some enforcement actions. I know that they are really on the lookout for on the hedge funds. They like to look at these little side pocket deals. They look at compliance with FAS 157. They look at kind of cherry picking. Sometimes people like to cherry pick from available quotes to increase asset values. That's an area. That's something that they've gotten onto, and they actually have had a few orders that have been issued. Last fall, they issued. There was a company named Agamis, AGAMAS Capital, and they were found to have failed on this very basis. So those are the kind of things that the SEC is looking. Examples of the things SEC is looking for. So what are you going to do? In terms of your own advisory practice, what are you going to do in terms of valuation? I think all you can do is understand that it's a challenge, and when it's not a readily traded market, the SEC and everyone understands that it's a challenge, but all you can do is follow fair and good practices. I think it's important that people review their valuation policies to the extent you have one internally written into your compliance procedures. verify the disclosure about that policy that you're making to your clients and to the regulators if you're audited. Make sure to the extent that you're outsourcing or relying on any third parties for valuation that you're diligently and prudently and carefully and effectively monitoring what they do, how they do, when they do it. And finally, that you're keeping, good records of everything, just in compliance generally with the Advisors Act, and particularly to make sure that you have a good history on how these values were created, so you can establish who reported to who on what issue and why. Right at the 30-minute mark. I hope that was helpful. Our next webinar is in October. Because we have so many advisory and broker-dealer clients. A lot of times our materials and discussions are on the ERISA side. But I think for our next webinar, like today, I will continue on with some more specific SEC and FINRA topics that relate to the practices of our advisory and broker-dealer clients. And that'll be next month, and I will look forward to speaking with you then. If you have any questions about today, if I can help you with anything that we spoke about today, if you have any questions, please let me know. If you wanted a webinar or any reference materials that might have come up in the discussion, we'll be glad to send them to you. On behalf of the Wagner Law Group, thank you very much for joining us today.